Hello and welcome to the Rogers Brief. I'm Adam Rogers. Thank you for watching and thank you for listening. Just finished day 31 of the Mass Casualty Commission proceedings, and so I'm going to talk a little bit about that. Today there were two further expert panel discussions regarding critical incident responses. And there was also an interesting article that came out this morning on CTV News I want to talk about. As you may know, there's still an ongoing boycott by some of the participants and their lawyers. But there's an application forthcoming to the Commission, which I think, if they, depending on how they deal with it, has the potential to sort of amicably, or effectively at least, end the boycott. So we'll talk about that after we talk about the content of day 31. And I have a problem with the approach that the commission is taking here. The two panels included, about a dozen or so experts on critical incident responses. Some teach it. All of them study it in one form or another, and so these would be valuable individuals to talk about what took place. Except there was no discussion whatsoever of what took place on April 18th, 19th, 2020. There was one slight mention of it. The one local representative, Dr. L. Jones from Mount St. Vincent, in the second panel at the beginning of her remarks, when she was introducing herself, made sure to mention, I'm thinking of the families and the victims. But that was it. Otherwise, it was a academic, theoretical discussion about all kinds of topics dealing with critical incident response. The first morning panel was occupied by talking about the impact of stress on critical incident decision making. The afternoon panel dealt with sort of broader questions of social impacts, budgets of budgeting priorities of police departments, training, those sorts of things, differential treatment of marginalized groups, that came up a few times. So very interesting discussions, but in no way directly connected to the events of the mass casualty. So what's going on here? One thing, of course, that comes with this, you say, well, what's the problem, right? So we have the facts, such as we'll have, and there's more evidence coming. Okay, and then we have these expert analysis, we have reports we can read, and we can make connections. Okay, so if decisions were made this way and there was some confusion over who was in charge, okay, that's on one side. And on the other side, we have an expert that said, a couple of experts that said, well, it's important that you be very clear on the chain of command in a critical situation like this. All right, so we can certainly make those connections, but they are not being made directly by experts. So that's fine. And I'll describe a little bit how that's different in a regular civil and criminal trial in a second. But one of the key impacts of this is that you don't see any headlines in the newspaper or headlines in any media source talking about such and such Mass Casualty Commission expert highly critical of RCMP response in such and such a way. That story doesn't happen by the very manner chosen, the procedure chosen, which of course only benefits the RCMP and the established interest if you don't have those kinds of headlines. And this procedure really prevents that from happening. All right, so in a normal criminal or civil trial, what you would have is a situation unfolding. If it's a drug allegation, well, the person was found with this much marijuana, this much cocaine, this much whatever. That's too much for one person to consume. Therefore, we can infer that they're trafficking based on the amount, and you get expert opinion on that. Personal injury case, you get expert medical opinions to say, how injured a person is, what their capabilities are, all those things. If it's an engineering question, you have an engineer that comes in, talks about the structure and, what their analysis revealed about, how well it was built or whatever. Okay, so you have experts for all kinds of situations. But you get the expert in, you put them on the stand, and you ask them, okay, expert, we've go through your resume a little bit to establish that you are such an expert. Now tell us what you found out about this situation. And you learn about that situation. Here we are not learning about the events of mass casualty through these experts. We have to make, or hope that the commissioners properly make, those connections themselves. So that's an issue with this. I think it would have been better. I mean, some of these experts certainly, like I say, they're well qualified, interesting things to say, but we don't know what they think of this specific incident. They only talked about other things and hypotheticals. So I think that was an issue. It was also there. Well, I'll talk about the first one. The first panel this morning, there was some irony in some of the expertise, which I'll get to, which was in the second panel. The first panel talked about how it is tougher to make decisions while under stress and without enough time. Okay. Well, first of all, there was nothing that they said that anybody who had a little intuition about decision making and stress wouldn't have figured out themselves. There was nothing that was unintuitive about their expertise. Yes, when you're under stress, you make worse decisions. So, physical stress, mental stress, whatever it may be. Although you are going to have to make decisions under stress, so try to be good at it. Best advice seems to be take a little breath before you do anything rash. All right, so that just saved you 3.5 hours of listening to Krista Smith, moderator from the Mass Casualty Commission, Dr. Lawrence Allison from the University of Liverpool, Dr. Judith Anderson, who we heard yesterday, psychology professor at U of T, University of Toronto, Superintendent Wallace Gosson from the York Regional Police, Dr. Matthew McAllister from Texas State University, and Dr. Neil Shortland from the University of Massachusetts Lowell. By the way, just a side note, the Mass Casualty Commission proceedings ended at 5 o'clock. You notice when there's a witness, things end a little early sometimes. With academics, they could talk. They could still be talking easily. The second panel was moderated by Dr. Emma Cunliffe from the Mass Casualty Commission, featured Dr. Anderson again, Dr. Paula Di Nota from the Heart Lab at the University of Toronto Medical School, I think, UTM, Dr. Benjamin Gold from the Allard School of Law, UBC, Allard, Dr. Kimmo Himberg, we heard yesterday as well, Police University College in Finland, Dr. L. Jones from Mount St. Vincent, and Dr. Hunter Martindale, we heard yesterday as well. So, anyway, lots of expertise. One of the things they talked about, and this was the part I found ironic, was they were talking about making decisions without enough time and under, where information is imperfect or incomplete. Well, there's the Mass Casualty Commission, which has a fairly strict time limit, we think, November, when they have to have a report done. And so they have a limited time, and they are imposing on themselves limited information because, they're wasting these days now, 2 days now, I'd say, listening to these expert discussions, who I'm sure they're all fascinated to have them, but they also have submitted papers, and they, if they had testified about the actual events, I think it would have been much more helpful. So, yes, limited time. They will end up now, certainly, with more limited than necessary information, and they're going to have to make important decisions under those circumstances. So we'll see how the commissioners handle that. I think it was Dr. Gould, but it might have been Dr. Himberg who called the decision avoidance cognitively lazy. That is, people who always wait for more information and just fill the time with vaguely relevant discussions rather than digging into the details and having experts talk about actual events. All right, so that's enough about that. Some of the points that came out of the afternoon session, actually one from L. Jones I thought was quite interesting, who is a co-author of the Halifax she's Board of Police Commissioners Subcommittee Report on Policing. I think a lot of people probably didn't read it because it talked about defunding in the title, I believe, and prominently. Actually, I did read quite a bit of it. It was quite compelling, particularly about police reform and dealing with racialized minority communities, individuals. So coming at things from a different approach than the mass casualty analysis would seem to lead, but I think both sides talking about police reform throughout Nova Scotia. She also referenced in the course of her remarks the Wortley report from Dr. Scott Wortley on street checks. So that was kind of interesting. There was comparatively little study done in Canada, we are told, about police decision making compared to other jurisdictions. So that's interesting, where RCMP is sort of the national force and there's been very little study. Public trust and reform. So that was discussed. Now, if when there are problems with the police, and the old adage, I guess, it takes a lot longer to build than to lose. It can be lost very, very quickly, and very difficult to rebuild once lost. And Dr. Himberg from Finland said, you guys may not know Finland very well, which is probably true, but we have the highest police trust rate in the world. I think it was 91% of citizens there trust the police. Their total shots fired by police last year was 2. The year before was 7, so very small. And so they talk about not police training, but police education. Just seems like a fairly different approach, one that could be studied independently. Okay, so that was the day. Didn't, interesting at times, but not particularly relevant, or not certainly as relevant as it easily could have been. Okay. So CTV News piece this morning quoting Tara Miller, quoted Sandra McCullough as well from Patterson, but Tara Miller was the one that raised this point, which is that she is on her client's behalf going to make an application to the commissioners to change the rules of procedure. Of course, you see some of the parties are boycotting because they're not able to cross-examine. They're really being marginalized as participants. That's the most prominent example. So she's going to ask that the commissioners amend their own rules. Okay, so the legal side of it is this. The commission was created by joint orders in council, orders from the provincial and federal cabinet, which are identical, and then authorize the commission. In the course of authorizing the commission, they authorized the commissioners to adopt any procedures and methods that they may consider expedient for the proper and efficient conduct of the joint public inquiry. Okay, so they can make the rules themselves about procedure. And there are 2 that are relevant. One is, that's number 7, the commissioners may amend, vary, or depart from any rule as they deem necessary to ensure the commission is thorough, fair, and timely. So that's Rule 7, so they can change their minds. And Rule 52 is the rule Ms. Miller is looking at, and it says that, I'll read the whole thing, but the first part is the most relevant. It says, participants may have an opportunity to question the witnesses to the extent of their interest as determined by the commission. Subject to direction from the commissioners, commission counsel will determine the order of questioning. The commissioners have the discretion to restrict the scope or manner of questioning. Okay, so the last part, the scope and manner, means your question needs to be relevant and you can't be, uncivil or hectoring or you can't just be, uber aggressive to the witness. So that's just those are sort of relevance and behavioral considerations. The first part is the one that's relevant, which says, I'll say it again, participants may have an opportunity to question the witness. Ms. Miller's application is going to be to change that may to a shall, so that would be participants shall have an opportunity to question the witness. It would still be limited by the second part of that, which is to the extent of their interest as determined by the commission. So that mostly means not the main participant groups who really have an interest in all elements of this, but rather if you have an organization that's dealing with and has a narrow focus, well, they wouldn't just get to ask questions of every witness that jumped in, that came onto the stand. If it's so I think so. Here's what I don't know if the commissioners will see this as an olive branch and grant it, because there's nothing preventing them now from allowing, just within the way the rule is written currently, there's nothing that prevents them from allowing vigorous cross-examination from all parties. It's in, they may have an opportunity, well, then commissioners could give them that opportunity. If they shall have the opportunity, that means the commissioners couldn't stop them from it, except to say, well, you don't have an interest in this witness, which would be a limited use, because most of the main participants would have an interest, like I say, in all witnesses. But, why would they make that change when, they've already, within their discretion, sort of decided how things are going to go? Maybe they'll see it as an olive branch and do it just to have it done. If they don't, the next and only other option, as I see it, is to have the original order in council changed to not just simply authorize the commissioners to make their own procedures and methods, but to specifically allow for cross-examination and to have some other language in there that reflects the situation as it's unfolding. More witnesses, better cross-examination rules. So that was interesting. We'll see if the commissioners react to that. They didn't mention anything in their remarks today that would suggest that they were really thinking along those terms, but the news story only came out this morning, and the application may not have been made yet. Probably hasn't been. So I wasn't surprised when they didn't mention any application that hasn't yet been filed, probably. So anyway, we'll see where that goes. That was it for this week. We'll be back next week for further hearings. I think 4 days next week. If you're in the Sydney area, or if you're checking out things, I'm on Coastal Radio on Sunday at noon on Dialogues. Did that interview the other night, and so that was an interesting discussion just about some of the big picture stuff with the commission. And so that's it. Until then, we'll thanks again for watching, thanks for listening, and we'll see you next time.